Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 152 of the NCDWI Guy podcast. On today's episode, we are talking about the rights of the defendant, the rights of your client, versus the opportunities of the officer. So, rights and opportunities, what do I mean by this? Well, in the context of a closing argument, I think it can be very powerful to speak to certain rights that your client has in the kind of larger context of rights that are meant to protect a person charged with a criminal offense. So we'll kind of work through that laundry list and explain why it's helpful to kind of see this in the bigger picture and all of the rights that have been kind of carefully selected for a defendant. In terms of the opportunities of the officer, this is something that I frequently have referred to in closing arguments, pointing out where the state had the opportunity to kind of look under a rock and intentionally chose not to. The state bears the burden of proof. They have the responsibility for proving each and every element of the case beyond a reasonable doubt. The burden lies entirely with the state. And so if you have that burden, why would you not exercise every available opportunity in terms of the collection of evidence? Why would the officer not do that? So in terms of today's episode, we're going to primarily look at this in the lens of a refusal, a breath or blood refusal by your client. That basically we're kind of look at this as a specific example, kind of in that context. If you have a refusal case, go back and listen to episode 127, which was about evidence of refusal in a DWI trial. And so you can get some ideas in terms of other ways of attacking a refusal. But this episode today is not primarily, it's not limited to as a refusal case. We're just going to use that as kind of like one place where you can see how this could be a powerful argument. So when it comes to the rights of your client, you want to kind of draw out some of this through testimony, although I think it's more important that you can just kind of point to the Constitution of the United States, the Constitution of North Carolina, the other statutory rights and case law rights that are allowed to a defendant. But I think it's important to look at some of the rights that are allowed to a client. And so again, in the context, let's say you have a client that refused chemical testing. And the other evidence of appreciable impairment, maybe there's, slurred speech or unsteadiness on feet. Your client does, decent on standardized field sobriety testing, no red glassy eyes, answers all the questions, doesn't have any difficulty in terms of turning off ego. There's some evidence kind of going both ways in terms of appreciable, but not somebody that appears on video as just kind of grossly impaired. When you have this refusal in that context, what is the state going to do? The state is going to hammer that refusal evidence, and they're going to point to the North Carolina pattern jury instructions that we kind of talked about how to explain and diagnose back on episode 127, how to kind of explain that pattern jury instruction. But they're going to point to the statute and jury instruction on refusal. that refusal basically, if a person refuse that evidence along with all of the other evidence, can go into deciding whether the defendant is guilty, which basically is a meaningless instruction. And again, we've already diagnosed that on episode 127. Of course, you have to look at all the evidence. So the fact that you have to look at the refusal evidence along with all of the other evidence is effectively saying nothing, which is why it's kind of a stupid instruction in the first place. But if that instruction is granted, you want to be able to deal with that instruction. So, when you are talking to the jury about the right to refuse, I think the prosecution presents this as this defendant, this person, Mr. Smith sitting over here at the defense table, he knew he was going to be above the legal limit. And so he willingly chose not to blow. He knew that he was guilty of this. And so he decided he would rather refuse, that he didn't want to give his breath sample, something along those lines. Who knows exactly what they're going to say, but they're going to point to the statute, ask for the jury instruction. And so how should you respond? Well, maybe just respond by pointing out that there are a lot of rights that are available to a defendant, and they're meant to be exercised. It's the defendant's choice, but they're meant to be exercised. So explain some of the rights that people, individuals, every person that is a citizen of the United States and a citizen of North Carolina has when it comes to being charged with a crime. So if we look at constitutional rights under the Fourth, Fifth, Sixth Amendments, we find a number of rights that a defendant has. The right to be secure against unreasonable searches and seizures, the right to effective assistance of counsel, the right to plead not guilty, the right to a speedy trial, the right to a jury trial. And you can see, members of the jury, that my client has exercised some of these rights: the right to have a jury trial, to put this in your hands, the right to plead not guilty as he has done. Additionally, the right to be informed of the nature and cause of the accusation, the right to be confronted with witnesses against him, the right to subpoena witnesses for the defense, the right to testify and present evidence at trial, the right to not testify or present evidence at trial. All of these are rights that the defendant has. And do we get excited if the defendant, if my client, I'm gonna say defendant, I would never say this in jury, I would talk about my client or better than that, Mr. Smith, or whoever my client is. Are we going to get upset that Mr. Smith is exercising his constitutional rights? No, we're not. We're not gonna blame him for exercising his rights. The right under Miranda to remain silent after one is in custody or under arrest. And I'm moving on from the Constitution. The right under Brady to exculpatory evidence. If there's evidence that the state has, that's got to be given over. The defendant has a right to that. The North Carolina Constitution gives a number of rights to defendants, some which are the same as are given in the U.S. Constitution, and some which are additional, and one that's particularly important in the context of refusal. Right to a unanimous verdict in criminal cases. The right to a unanimous verdict in criminal cases. So it's not just the right to a jury trial, but to a unanimous verdict. The right to confront accusers and witnesses, just like in the U.S. Constitution. The right to counsel, just like in the United States Constitution. And the right to not be compelled to give self-incriminating evidence. Under Article 23, my client has the right to not be compelled to give evidence. So when we're talking about this in front of the jury, we're talking about these rights that a person has, under the U.S. Constitution, under the North Carolina Constitution. In a DWI case specifically, the defendant has statutory rights: the right to refuse standardized field sobriety testing, the right to refuse a portable breath test, the right to refuse a chemical test different from the portable breath test, the right to have a witness for chemical testing, the right to a first appearance before a district court judge within 72 hours or at the first regular session of court in that county, whichever occurs first, the right to release, timely and speedy release, as articulated in State versus Knoll and the cases that explain that, the right to communicate with counsel and friends post-arrest, and the right to get independent testing. So if you look at all of these rights, again, I think what this state does when it comes to refusal, when it comes to refusing chemical testing, is they say, look at the defendant. He has exercised his right to refuse. But they don't say it like that. They just say he refused testing because he knew what was gonna happen. He knew that he shouldn't have been driving. He knew that he was impaired, right? But when you look at all these different rights that the defendant has, some of which your client may have exercised, some of which your client may have waived in the particular case, if you explain it in the larger context that, no, my client has rights under the U.S. Constitution, under federal case law, under the North Carolina Constitution, under statutory law and North Carolina interpretation of North Carolina constitutional and statutory law, my client has a number of rights that he is allowed, and refusal is one of those rights. It's one of those many rights that my client has. And, I would particularly zero in again on the section from the North Carolina Constitution, because I just think that is such a powerful section. Again, I think I said Article 23. I meant Section 23. So under Section 23 of Article 1, we have the rights of the accused, and one of those rights, again, is not be compelled to give self-incriminating evidence. That's a North Carolina constitutional right. Okay. And yes, my client may have exercised that constitutional right, but that is something that, when you look at all of these various rights, it's just singling out this exercising one right. The state's not over here complaining that my client exercised their right to a jury trial. They're not complaining that they exercised their right to have effective assistance of counsel. They're not complaining that my client chose not to exercise their right to refuse standardized field sobriety tests, which my client did in this case. They're not putting their arms up when they are not pointing out that my client chose to waive this particular right. When we zero in on this one right, it becomes a problem. So I think when you can think through it in that fashion and basically explain to the jury all of the various rights that your client has, and again, these are rights that basically the defendant is not required to get on the stand and drink, some sort of truth serum and spill their guts. Like, that's not what is mandated. So if you talk about the importance of rights, find a quote. There's a quote from Thomas Jefferson: the equal rights of man and the happiness of every individual are now acknowledged to be the only legitimate objects of government. Repeat that again. The equal rights of man and the happiness of every individual are now acknowledged to be the only legitimate objects of government. The whole purpose of our criminal justice system when it comes to the jury system and trying criminal cases is that we acknowledge that the defendant has certain rights that they are free to exercise. So think through how you want to kind of go through that. Do you want to ask some questions about, did you know that this right exists during voir dire? Do you want to ask the officer during cross-examination, you understand that a defendant in a criminal case has XYZ rights. Is that correct? And you don't have any problem with those rights being allowed to the defendant under the Constitution of the United States and North Carolina. Do you have a concern with a defendant having the right to not be compelled to give self-incriminating evidence? Do you have an issue with that? If you ask these kind of questions throughout the trial and kind of put that into the jury's head, it's really going to de-emphasize this kind of ludicrous statement by the defense or by the prosecution of, look, this person refused, right? Like, how crazy would it be? Obviously, hopefully you get a jury instruction that does not allow for the state to kind of reference the defendant's silence, but it's just a crazy argument that basically the defendant is choosing to exercise his rights, therefore you should convict. Literally in most refusal cases, and I would say particularly at the district court level, there is so much weight put into the refusal, so much weight, which is literally a defendant's statutory right. And I think you could even connect it to that constitutional right to not be compelled to give self-incriminating evidence. So I think if you can kind of put it into that context for a judge, but certainly for a jury, you can explain again that it's important. So part of the reason that we have a jury system is that the jury is responsible for being the protectors of a person's constitutional, whether it's state or federal, and statutory rights. That's part of the analysis. So to go on to the other side, and this is something that, again, we'll maybe talk a little bit about how this would apply in a refusal case specifically, but I think it's so powerful to do regardless of the type of case that you're arguing. When an officer is missing an opportunity to collect evidence, hammer on that. Hammer on that. It is the state's burden of proof beyond a reasonable doubt. So when you're talking to the jury, obviously remind the jury or the district court judge, remind the judge or jury, it is the state's burden of proof beyond a reasonable doubt to show that my client is guilty of driving while impaired. The officer who investigated this case knew that at the time of his investigation. The burden of proof that you're now being asked to consider didn't come as news to him at the time of the investigation. He didn't think he needed some lesser standard of evidence in order to get a conviction at the time of his investigation. Didn't believe that there was some lesser standard. So he knew the high level of proof at the time of the investigation. And so you would think that somebody with that type of burden, the highest burden in the land, would do everything they possibly could, dot every I, cross every T, in order to make sure that they have done everything possible to get a conviction where they believe that the defendant is committing or has committed a crime. You think they would again turn over every rock. Great quote from Benjamin Franklin here that you can put forward to the jury. This is from good old Ben Franklin. To succeed, jump as quickly at opportunities as you do at conclusions. To succeed, jump as quickly at opportunities as you do at conclusions. Maybe you can lay this out as Benjamin Franklin has laid out the roadmap for the state to get a guilty verdict in this case. And here's what he says. To succeed, jump as quickly at opportunities as you do at conclusions. So put put Ben Franklin as the guider of the guider of the jury. So another quote, think of a good quote that kind of allows for opportunity. When opportunity knocks, you better let him in and sit him on down and try to be his friend. I like the Benjamin Franklin quote better, but find a quote that makes sense when it comes to this, and then look at whether the officer took advantage of all the opportunities the officer had to investigate the crime of driving while impaired. So you can say the officer had the opportunity to stop if he sees reasonable suspicion or probable cause, but he also had the opportunity to continue to follow my client and get more evidence of reasonable suspicion. Yeah, he stopped for speeding, but again, as we talked about already, members of the jury, that's not evidence of driving while impaired. And there was nothing preventing the officer from continuing to follow my client. Bad tag. Great argument for a bad tag case. Yeah, he could have stopped, but he didn't ultimately cite my client with the tag because, again, that's not the reason that he was stopping. He was stopping to look for something more, and in fact, he could have continued to follow my client, seen if there was any evidence of bad driving, but didn't exercise that opportunity. So if there's a lost opportunity that the officer is not taking advantage of, point that out. Point out opportunity to ask questions before Miranda warnings attached. I cannot tell you how many DWI investigations I've had where the officer does not ask my client if they have been drinking or how many drinks that they consumed. Unbelievable. I mean, on a DWI case where you have just done a traffic stop, Miranda warnings are not required at the point that you just walked up to the window, that before you start your investigation, before you put the person under arrest, you haven't asked, have you been drinking? How much have you had to drink tonight? The questions that we fully expect are coming in every investigation, just not present. Point that out. Didn't you care how, if my client had been drinking? Could you have asked that question? Why? Why didn't you ask? There's no good answer to that question. Whatever with there's a catch-22 there. There's no good answer to that question. You had the opportunity to request standardized field sobriety tests. They're properly trained. Did you offer standardized field sobriety tests? Did you offer all the standardized field sobriety tests if the officer maybe only does HGN or only does walk and turn or only does one leg stand and HGN? Why wouldn't you use everything at your disposal? Now, there may be some sort of legitimate response to that based on terrain or whatever it might be. So hopefully you've been able to pull that out by talking to the officer before you begin trial or at district court or wherever it might be. So, hopefully you know the answer to these questions before you ask them. But again, if there's no good reason for not, even despite the answer, sometimes really truly no reason for not doing this, then why not? Why are we not exercising that opportunity? Opportunity to request a portable breath test. Did you ask for a portable breath test? Why not? Opportunity to call a more experienced officer. If it's clear that the officer doesn't know what he's doing at the roadside, did you request a DRE to come out? Did you request a DWI task force officer to come out, a supervisor, somebody that could have done field sobriety tests, somebody that could have walked you through this experience since you just testified that you've only had, you'd only investigated 4 prior DWIs over the last 5 years? Did you think it might be helpful to have somebody that was a little bit more vetted in this particular process? And again, maybe it's that there's nobody available, but did you make the attempt? Was there a request to have somebody else come out and supervise or take over the investigation? The opportunity to request chemical analysis. Did you request a breath test? If you did, and that wasn't consented to, did you, as an alternative, say, would you be willing to give me a blood test? this is particularly important in the context of refusal and something that I really hammer on: opportunity to get a search warrant to draw blood. Consent is the exception to the search warrant requirement. So yes, you can ask somebody if they will give you blood, but then if they exercise their right not to do that, you don't just have to just go away crying and say, well, this isn't fair. Like, why can't I, as the officer, get some sort of chemical analysis? No, you go to the magistrate, you get a search warrant to draw blood, you come back and take the person's blood. This is the evidence that just is so baffling to me on refusal cases. And this is one of those areas where if there's not great evidence of appreciable impairment, it's just mind-boggling to me that somebody could ever be convicted of a DWI without a search warrant. Because if somebody's exercising their right to refuse and it's the state's burden of proof and they have the ability to go get a number, to go get a chemical test done, why are they not doing that? To me, there's absolutely no good reason for not doing that. Again, maybe circumstances prevent this. Maybe they say, I called for a search warrant. The magistrate on that was on duty was not available, or said that it would be 6 hours before they'd be able to get to me. Again, there are understandable circumstances that would make this difficult, depending on the county, time of day, how many people there are at the jail, all kinds of things that could go on. But did you attempt to do that? Did you try to get this fill in the blank form signed? Or did you just basically say, okay, this person's refused, that's enough, we're going, let's move on to the next case? That's a crazy assumption to make when you have basically within your capability prima facie evidence of impairment. Why would you not, or per se evidence of impairment? Misused that language. When you have the ability to get per se evidence of impairment, why would you not do that? Officer has the opportunity to search the vehicle. Did you search the vehicle after arrest? Opportunity to search the area around the vehicle. Did you look around the vehicle if driving is in question or possible, consumption of alcohol afterwards? Did you look in the vehicle? Did you look around the vehicle for any type of open containers, for signs of drinking at the time of driving? If for somebody that's been doing it for a long time or has been an officer for a long time, how about opportunity to get additional training? You indicated that you've been through basic law enforcement training 27 years ago. Have you taken any classes on impaired driving since then? Okay, why not? And if not, then do you think this might have been a better case for somebody else, with somebody with a little bit more experience? Opportunity to Mirandize and then question. So post arrest or post your client being in custody, did the officer take advantage of the ability to Mirandize and ask questions? I see all the time where that DWI form, the second sheet is blank, and it's not blank because my client didn't exercise or exercise their right to remain silent. It's blank because the officer basically just said, well, I'm not going to ask the question. Crazy. I'm just not going to Mirandize. We've got what we need. Why would you not go through the full gambit of opportunity for investigation? So, again, this is something that I think can be really powerful when it comes to voir dire, actual cross-examination and closing argument, is painting the picture that when your client exercises their right, that is what the Constitution and our laws in North Carolina are designed to protect. When the state fails to exercise an opportunity to investigate, they are basically showing that the process doesn't matter, that they would prefer conclusions to opportunities in terms of their chances for success. When you miss an opportunity to investigate, you're basically saying that we've got this one in the bag. It doesn't matter. The jury can just trust us. when you have an officer that's done it all, every single field sobriety test, asked all the questions the right way, gotten the the search warrant to draw blood, and it's above the legal limit, it's really hard to fight those cases because the officer is doing what they're supposed to do, which is to investigate the case to get the evidence necessary to get a conviction proving to the jury beyond a reasonable doubt that your client is guilty of driving while impaired. When they exercise those opportunities, it just shows that they are doing their job. When they miss those opportunities, it shows that they're not doing their job. So I think using this opportunity versus rights distinction is a really powerful way of bringing this out to the jury. If you have an individual case that you think might fit somewhat into this mold, and you want to bounce that off of me or one of the other attorneys at the office, feel free to reach out. Be happy to talk about it with you, and what some of the issues on your case might. How those might fit nicely into this type of a narrative. So feel free to reach out, bounce a case off of us. Hope this information has been helpful, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.